Thank you very much, Jeff. I appreciate the introduction, and it's always a pleasure working with you and AOA. You guys have been a big support for our firm, and we're very happy to take on any of your clients. And as always, thank you very much for the introduction. Good afternoon, everyone. My name is Bijan Shakibkoo. I am, let me go ahead and actually get the screen shared. My apologies. All right. All right. Good afternoon, everyone. My name is Bijan Shakibkoo. I am a co-founder and managing partner over at SNS Law Group. My practice areas are really a range of things in the real estate realm. I've practiced in the real estate realm and have done many work within the real estate realm within the past decade. But specifically within the legal realm, my practice areas are, unlawful detainer actions, real estate litigation, contract disputes, a lot of business litigation, landlord-tenant disputes, quiet title cases, partition cases. So here at our firm, we really handle a real broad range of, real estate practices. And, today what we're really going to talk about, and, what's been coming up a lot in our firm, and, we've been having a lot of clients give us a call about, is habitability issues. And right now, what's been going on in especially in the residential realm of real estate for landlords is a lot of tenants are filing lawsuits right now for habitability claims. And the way that they're really articulating this is kind of like how I look at it is a Ponzi scheme, and they're trying to put a landlord in a position where they could take money from them. And, we have about well over a handful of cases that we're defending landlords on habitability claims. So let's just...
And before you get started there, can you do the share screen thing so that it shares the...
Oh, of course.
The tile, the view. There we go. I've got the right view.
Perfect.
Thank you.
Sorry. So let's get started. What we're really going to talk about is, habitability lawsuits and how to really avoid them. And like I said earlier, this is coming up a lot, and it's kind of similar to these ADA lawsuits where you'll get a individual who is handicapped or disabled, and they'll come onto the property and find issues in the property that are not per code, and they'll turn around and slap a lawsuit to collect money at the end of the day. And this is what's happening now. And a lot of these tenants are also defending themselves in eviction cases based off of these habitability claims as well. So let me dive in here. The first thing that, I really want everybody to get an understanding, typically when a landlord is receiving a lawsuit under a habitability claim, it's really focusing on the cause of action of an implied warranty of habitability. And what that means is typically that, landlords have a duty to be able to maintain their rented properties in a habitable condition. So that means when they're signing a lease contract with their tenant, there is an implied warranty that that unit or that dwelling is a habitable dwelling. And it's in every single lease agreement, primarily specifically residential lease agreements, that it's implied. And specifically under the Civil Code 1941.1, which is a very important civil code for a lot of landlords to be able to understand, because that really gives you the guidance on what the standards are and what to watch out for when you're having a tenant occupy a unit, and to make sure that it's a habitable dwelling. And I'm going to dive into that right now. And, the conditions that would render, and that's part of the civil code as well, that would render the property uninhabitable is first insufficient waterproofing and weather protection of the building. So it's very important to, make sure to maintain the roof, make sure there's no leaks going on in the roof, and if there are any leaks, to address them, especially with the exterior walls of the building. If the exterior walls of the building are at credibility at issue, where there's water intruding into the building through the exterior walls, and that must be maintained. Any broken windows or broken doors, obviously, that has to be fixed as well. That's the landlord duty to do that, and that is a claim that tenants will raise in order to defend themselves in eviction action or ultimately file a habitability lawsuit against the landlord on. Another issues are plumbing and gas. It is important that all the plumbing and gas is in good working order. A lot of tenants, what they do is, and I've seen this on and on, where they'll try to actually create a habitability claim by doing the damage themselves, by going in and maybe damaging some of the plumbing or saying that they don't have gas in their unit. So whenever there is issues in regards to plumbing and gas within the dwelling, just make sure to address it, and also make sure that it's being done specifically by somebody who specializes in that type of work. And if permits need to be pulled, that's very important as well. Because a lot of the times, when we're getting into the nitty-gritty of litigation, what a lot of attorneys do is they request discovery, and they want to see, who's the person that went out there and conducted these repairs. And if they see that the individual was not qualified to do that type of work, it does really take an effect to the case. So it is important to be able to make sure that that individual who is going to be conducting those repairs or doing any plumbing or, addressing any gas issues, they have to be qualified in order to do that, and the proper, permits that must be pulled as well, according to, the building and safety codes as well. Another issues are water supply and temperature. We have to make sure that the tenant has access to water. So all the sinks, all the kitchen sinks, the bathroom sinks, the showers, that's all functioning, even towards the faucets too. If the faucets are having issues, that has to be repaired too. And that is a habitability claim that they could bring up. And they have a right to have hot and cold running water. So for example, if there's a sink that is only issuing cold water, that's an issue. It also has to have the choice to be able to have hot and cold water being given to the tenant as well. Heating facilities. Lack of heating facilities is very important for the tenant to be able to have heating in their unit. Now, a lot of landlords, and there's a lot of confusion onto this, but the civil code actually does not require that the tenant has a right to AC, which is air conditioning. They don't need to have AC, but they do need to have some sort of a heating appliance. So there needs to be some sort of heat being provided within that unit. And obviously, it has to be in good working order as well. Electrical issues in the unit, all the lights must be functioning correctly. Smoke detectors must be connected correctly. No faulty wires hanging, nothing that's going to cause a safety or hazard issue towards the tenant. And also they must be in good maintaining order. The whole premise around these is that, whatever is going on within the dwelling, it has to be maintained and it must be in good order. So if there's anything not working, it's important to address that. And we're going to get ahead of, further down in the slide about what that means. The building grounds, the common areas, areas that are controlled by the landlord, it has to be in a clean and sanitary condition. So that means it must be free of any debris, filth, rubbish, garbage, rodents, vermin. I've seen time and time with my clients where, the housing department will come out there and they'll just see, just a little piece of trash on the property. Or if there's any trash built up near the dumpster, they'll issue a citation for that and they'll give the landlord a notice to comply. And it's not fun dealing with the housing department and whoever has gone through it. It's definitely, they do give a headache. So it is important to keep the area of the common areas of the property or wherever areas that are in control of the landlord in clean and safe condition, especially safe. And we're going to get to that next. Other areas within either the dwelling or within actual, the common areas or the common grounds of the property. The floors must be in good condition. The stairways must be sufficiently per code. Some structures are actually considered historical, and given by the age of the property, if it is already passed and it's to code, it's not an issue. Sometimes, these newer buildings, they do require certain things to be up to code, but primarily, things that have to be maintained in good repair is the floors, the stairways of the property, and any railings. I've seen a lot of cases where within the dwelling, a lot of the floors would be bubbling up, and that's a hazard. And also it's a liability for the landlord as well, because if the tenant goes ahead and trips and falls, or a guest of the tenant goes ahead and trips and falls, and that's a lawsuit right there on its own. So it's very important to keep the floors, the stairways of the building, and any railings in good condition. Mail receptacles. So this is a little bit for landlords. I've noticed that they're under the presumption that, oh, they have a mailbox, so that's okay just because they have a mailbox. But it's also very important that the mailbox also has to contain locks, and it has to be conformed with the Postal Service standards. So if there is no lock for the tenant's mailbox, it is very important to get one, because they're going to raise issues as far as my mail is being stolen, I'm not receiving my mail. So it's very important to be able to assure that those mailboxes have locks and they're in good condition as well. So the health and safety code, it coincides with the civil code that we mentioned earlier, which is 1941.1. And typically when tenants want to hire an attorney looks through all these types of issues, they look at these two codes and see if the landlord is abiding by any of these codes. And it's very important. They really do coincide with one another. So just a blanket, it has to be, the unit has to be in adequate sanitation. If there's any improper water closets or lavatory or bathtubs or showers in the dwelling, it has to be in good condition. So nothing, a lot of my issues that I've seen with my clients who call me, they tell me that, the tenant doesn't like the color of the wall, or they don't, it's more like stuff that are more aesthetically pleasing. That's not really a duty that a landlord has to provide to the tenant. What's really important is that it's in a clean manner, it's in good condition. So long as it's in a good condition and it's not raising any health or safety concerns, then they're fine. So if they're not happy with a pink wall, then, it's too bad. The wall is pink. You can't raise a habitability issue on that. So any lack of improper kitchen sinks, lack of hot or cold running water, kind of similar to what I spoke about earlier, lack of adequate heating, improper operation of required ventilating equipments, any infestations, insects, vermin, rodents, and visible mold growth. Two things that tenants love to raise is infestations and mold. And I will tell you, with infestations, it is a very strong claim that a tenant could have, because when there's an infestation going on within the dwelling, it's pretty apparent. And if they have documentation of that, it's difficult to be able to defend on. So if there's any issues with any, infestations of bed bugs or, cockroaches or ants and stuff like that, it's very important to address those. Now, as far as mold growth, mold growth is very common right now. It happens in a lot of buildings, especially the older ones where they lack ventilation. On a legal standpoint, if a landlord is trying to, if the tenant is trying to file a habitability claim based off of mold growth, or they suffer damages from mold, it's very speculative in order to prove that in court. When it comes to mold, they really, mold takes time to build up. And then also the health concerns towards mold also takes time. And if the individual is obviously, allergic to mold, then obviously it will show up sooner. But individuals who are not that are not allergic to any mold, it really takes time for those health damages to rack up. So when we're going into litigation for mold issues, it's a hard thing to prove on the tenant's end. But at the same time, that if there is any evidence of mold in the unit, if they've gotten testing that shows that there's positive spores or high count of spores within the dwelling that have mold, it is very important to address that, because just by that report, it shows that there's mold in the unit, and it does bring a lot of liability towards the landlord. So mold is a very common thing. It's very important to advise your tenants to keep the dwelling in ventilation. If they need to, if it's a older building, maybe try to leave the fan on when they're taking a shower, or try to, if there's a window in there, to leave that window open. But if they do request, or if they do put the landlord on notice that there's any mold in the unit, it is very important for the landlord to be able to address that. So what are the landlord's responsibilities? And this is really, what I advise my clients to do. Anytime a tenant brings up any repair requests or any issues within the dwelling, I would first advise my clients to keep everything in writing and also document everything. If there's any request repairs being made, I would let the tenants know, if they want to make a repair request, to put that in writing so you have that documented. Because, really how the law works is that if the landlord has a duty to obviously provide a habitable dwelling, and if the tenant puts the landlord on notice of any conditions in the property and any conditions that need to be repaired, the landlord, oh, I'm sorry, let me just fix that. All right. The landlord has a duty to be able to they have a reasonable time to be able to address those issues. So it's, the statute is not very clear as to how many days does the landlord have to be able to address those issues. It's just a reasonable time. So depending on the circumstances, it's really a case-by-case basis. So if there is a massive leak coming from, the roof, and the landlord hasn't done anything about it in a couple of weeks, then that would definitely be unreasonable, and that would be a breach of the implied warranty of habitability. And like I said, to go back, just document everything. Everything should be in writing. Any communications between the tenant and the landlord should be in writing. I would respond adequately to the tenant, send somebody out there to take a look at it, and then also, if if it needs to be remedied, depending on the issue, definitely remedy it. So I think the biggest thing that I really want to stand out here is try to keep everything in writing and document everything. Take pictures of the repair requests that are being done. Take pictures before and after the repairs have been done. And if a license, and for example, if they're giving issues about mold, then it's very important to get a certified mold specialist in there to do a test and to take their report. Because if you're going to send a handyman there to go and, wipe down the wall where it shows that there might be some mold, that could be an issue, and the tenant could use that against you. So if they're claiming any mold within the unit, just make sure you get a certified mold inspector to get in there and get that fixed. So this is what the tenant can do in the event the unit is uninhabitable. And what they could really do here is, and this is the part where it really becomes a headache, and where you really start to see what kind of a tenant that you're dealing with and how they're trying to gather their evidence to use a habitability claim against you. The first thing they're going to do is go ahead and file a complaint with the governmental agencies. If that's the health department, Los Angeles Housing Department, building and safety, they're going to try to document as much as things that they can to use against you. So that's one of the things that technically, when I see an onset of a habitability case happening, what they will do is they'll first notify other governmental agencies. They'll get them out there. They'll conduct their inspections. They'll give the landlord a notice to comply. And the landlord does have a duty to comply to that notice. And if they don't, and if it's, especially if it's a rent controlled property, which a lot of landlords want to refrain from, is from the property being put into a REAP program. And once the property gets into REAP, it gets very difficult to get out. So it's very important to be able to, again, address all the concerns for the tenant. But what they will do first is go, get these governmental agencies in and then try to file a complaint with the housing department as well. I've had one case where, we had a client where he hired us just to begin a simple eviction. And now we're almost going over a year now in litigation. And this was just on an eviction action. And she raised habitability claims. She went and hired an attorney. The attorney filed a lawsuit for a habitability claim. She's still in the unit, hasn't paid $1 of rent in a year. And she's gotten all the governmental agencies involved. Unfortunately, the property did end up going into REAP, and not from the owner's fault at all. It's because the tenant was so articulated this in a way where she deliberately planned this to be able to put the property in REAP and also recover more damages on the habitability claim. And what a lot of tenants are doing now is they're actually failing to provide access to the unit. And that's a very common thing that's happening. They'll say that there's an issue with the unit, and when the landlord wants to come out there to fix it, they won't provide them access. And depending on how the property is situated, if that issue is not addressed immediately, it could drag on to a year worth of litigation. So one of the things they could do, like I said, they could go make complaints with the governmental agencies. They could abate their rent. They could choose not to pay their rent. They could repair the issue in the unit and then deduct it off the rent. And then they could also use that as a defense towards an eviction case, which is similar with the case that I was just speaking about earlier. We started by filing a simple eviction case, and then she raised all these habitability issues. And I advised my clients, given the circumstances and given the evidence that she has, I think it's better if we're going to have to dismiss this case and address these issues and then refile later. So they could defend on that. It is a very common thing to do, especially for non-payment of rent. So if they're not paying rent and, if there's habitability issues in there, they have a right to not pay rent. And then ultimately they'll end up filing a lawsuit for the habitability issues. So, it's very important. If you're looking to file an eviction action, just make sure that you have addressed all of the tenant's repair requests and to make sure that that unit is habitable. Because come to find out, once you file that eviction, if that unit's not habitable and they have documentation of that, it will be difficult to get that case through. And probably it might get tossed out and they'll succeed.